Before we get started, we have one brief announcement. So I'm going to turn it over to, sorry, I forgot your name. Jillian for an announcement.
Hi everyone. For those that don't know me, my name is Jillian Spring. I'm a 3L and I'm in charge of Law Review Symposium. Given the high attendance of everyone here, I think you may be interested in our symposium topic. We're talking about constitutional shifts, shifts in constitutional interpretation. We'll be discussing birthright citizenship, reproductive rights, and education law. Shameless plug, it's Friday, April 17th. Food, lunch will be provided. There will also be optional networking hour once the event concludes. You can RSVP in the email that was sent out earlier today, and you can feel free to come to one or all of the panels, and I hope to see you all there. And there's flyers for everyone here. Thank you.
All right, thank you, Jillian. So those, if you still want to get food, please go ahead and help yourself. But we'll get started here while people are making their way through the food line. So as I said, this is the final event for this year in the Dean's Democracy Series. I just want to thank Professor Abriel, who I saw a minute ago over here. Thank you. And Teresa Koprova also for really doing the bulk of the work and organizing this whole series. And the Dean, since he's here, thank you to the Dean for funding this series. And the theme of the series overall has been really to talk about the rule of law and looking at different sort of current threats to the rule of law. So the topic today is the rule of law in armed conflict. And we have a great panel here. We're going to lead off with Professor Dalton, sitting to my right, who teaches a course on the law of armed conflict and also runs our summer program in The Hague, which focuses on international criminal law. I'm going to speak after him. If you don't know me, my name is David Sloss. I'm a professor here. I also teach this sort of course on the general introduction to international law. Then after me, we will have Professor Francisco Rivera. He is the director of our International Human Rights Clinic. He's going to talk some about the linkages between the law of war and international human rights. And then last but certainly not least, Professor Britton Schwartz, who is the deputy director of our International Human Rights Clinic, who's going to give us a little bit more of a sort of an international human rights perspective here. So I think that's plenty by way of introduction. I will say we're going to try and keep our opening comments brief so that we allow plenty of time for audience questions afterwards. So I am going to time each of the speakers and cut them off if they go over their time, including myself. All right, go ahead.
Great. Thank you. Thanks to everyone for being here and engaging in this topic. So I thought what I would do is sort of give you the kind of crash course in what is the law of armed conflict. And to put it simply, this is a set of rules, usually at the international level, that govern the conduct of actors or belligerents during armed conflict or war. You'll notice I use armed conflict. We've sort of moved away from defining it as war because, as you might notice, most countries don't actually declare war. So this is a distinct area of law from the law that governs the actual use of force, right? Starting a war. What I'm talking about is the law that governs the behavior during the conflict. Sometimes we call this jus in bello. This law only applies during armed conflict, and that's really important because that is a key threshold condition that must be met for this area of law to apply and makes it different from other areas of law like human rights, which I'm sure we'll talk about. There's sometimes overlap, especially when we're talking about accountability, but the law of armed conflict is only applicable during armed conflict. So this body of law comes from various sources, most notably treaties. You've probably heard of some of them, the Hague and Geneva Conventions being some of the most famous. And it's also composed of customary international law norms Those of you that have taken international law know what that is, but it's largely law that's created by state practice in conjunction with a sense of obligation. It has ancient roots, so this is not something that's new, but it's really been developed in the last few decades. And most notably, the United States has been a big part of that, so we can talk more about that later. The purpose is really to constrain suffering and limit harm to civilians and non-combatants. Right? That's kind of the core purpose of this body of law. And the right of parties involved in an armed conflict to choose the methods and means of warfare are not unlimited. Right? There are limits to what you can do in war. So 4 principles you should keep in mind as we talk about this body of law. Those are distinction. So the parties must distinguish between combatants and non-combatants, or combatants and civilians. Proportionality, where attacks causing excessive civilian harm compared to the direct military advantage are prohibited. Military necessity, which requires that only necessary measures to achieve a legitimate military goal are allowed. And finally, unnecessary suffering, or prohibition against unnecessary suffering, where weapons and tactics that are of a nature to cause unnecessary suffering or superfluous injury are prohibited. So the title of today's panel discussion is The Rule of Law in Armed Conflict, and I just want to emphasize the fact that this body of law exists is a triumph of the rule of law. The fact that we have rules that govern behavior in conflict should be something that we should celebrate and should continually work to reinforce. I might save some additional comments about contemporary topics, namely the use of artificial intelligence and the concerns over autonomous weapons, to later parts of our discussion. But using those 4 core principles as our guiding framework will really help understand what does the law require during an armed conflict.
Okay, thank you. Well under the time, so thank you. I'm going to turn on the timer for myself now. Okay, so generally when we talk about the law of war, there are 2 Latin terms that sort of define the parameters of the law of war, which are the jus in bello and the jus ad bellum. Professor Dalton was just talking to you about the jus in bello, which is the laws governing armed conflict after armed conflict has already started. Jus ad bellum is about the rules governing the initiation of armed conflict. When is it okay to start an armed conflict? And the general rule here is codified in Article 2, Paragraph 4 of the UN Charter. And what that says, in effect, is the initiation of armed conflict is permissible only in 2 circumstances, and that is for self-defense or if you have authorization from the UN Security Council. And the implementation of that, what I'll just call the prohibition on use of force, that's a sort of shorthand for this. Implementation of the prohibition on the use of force has always been imperfect, but there's a lot of evidence out there that once the international community decided to codify this prohibition on the use of force in the UN Charter, the use of force in interstate armed conflicts decreased significantly, right? It actually had an impact in reducing the frequency of warfare, right? Because we had this legal rule that everybody agreed to that basically said you're not supposed to use force except in these 2 narrow circumstances. As I said, compliance was not perfect, but it was pretty good. That started to erode with the War on Terror, U.S. response to the attacks on the World Trade Centers in 2001, and also with the U.S. invasion of Iraq in 2003. But I would say that there was generally still respect for this prohibition on the use of force up until pretty recently, and we see that in one of the corollary rules here is if a state does use force, they have to report that to the Security Council and they have to justify it, right? And states have actually been pretty good about complying with that. You can argue whether those justifications are persuasive, but states have been pretty good about when they do use force, they report it to the Security Council, and they at least attempt to make a plausible justification for why they think this is legal under the rules governing the use of force. Up until recently, I would have said the most flagrant violation of this was when Russia invaded Ukraine a few years ago. And when that happened, I was prepared to get out and make an argument that this was significantly different from the U.S. invasion of Iraq in 2003, that this was really a more egregious violation than what happened with our war in Iraq. But it's hard to say that what Russia did with Ukraine is more egregious than what the U.S. has done in Iran. This is one of the most blatant violations of Article 2.4 that's ever happened. And I think this comes back to a really important point which I want to emphasize, that ultimately international law generally, and the prohibition on use of force specifically, depends on what scholars have called norm internalization. And there are two aspects of norm internalization. One is that a norm that's established at the international level gets incorporated into laws and regulations at the domestic level, so that it actually gets internalized into procedures within institutions. And the other is that aspect of norm internalization is more psychological. We internalize these norms as individuals and take them seriously as moral prohibitions that guide our individual behavior. And what we're seeing in the last few years, which is very concerning, is a real breakdown of norm internalization with respect to this prohibition on the use of force, both at the institutional level and at the individual level, and especially, although not exclusively, here in the United States. I mean, I could talk a lot about Russia too. I think we see a similar problem in Russia. But, Donald Trump and Pete Hegseth just don't believe in these norms, don't respect these norms, and therefore the norms are not really being applied within U.S. institutions right now, and I think that's a huge problem. But I will stop there and pass it to my colleague, Professor Rivera.
Excellent, thank you. So good afternoon, everybody. I'd like to talk about three things this afternoon. First of all, the overlap between international human rights law and international humanitarian law. And then I'm going to provide a general overview of the relevant accountability or enforcement mechanisms, and then explain the veto power at the UN Security Council and why it matters. So law, accountability, and challenges. So let me start with the relationship between international humanitarian law, which is the law of war or armed conflict, and international human rights law, right? So at a very high level, we're talking about two legal systems that are complementary, right? They complement each other. They share the same goal, which is to protect human dignity, right? That's the basis of it all. How? Well, by prohibiting torture, by protecting human life, and by ensuring certain procedural guarantees, even during armed conflict. But they operate a little bit differently. So IHL, as was mentioned before, only applies during an armed conflict, whereas human rights law applies all the time, in peace or in war. And human rights law governs how states treat individuals. That's the basis of human rights law. So if you look at conflicts like Israel and Palestine and Gaza, Russia or Ukraine, both bodies of law apply simultaneously. But the key question has been whether IHL, humanitarian law, can be treated as lex specialis. We love, Latin terms. If there's an armed conflict, the traditional view is that when both apply, IHL is actually the more specific rule that governs, the battlefield conduct. But as recently as last year, the European Court of Human Rights, in a case called Ukraine and the Netherlands versus Russia, clarified that IHL is not automatically lex specialis governing all actions in armed conflict. That court has prioritized international human rights law, emphasizing how they complement, over the strict hierarchical sort of lex specialis approach that has been the traditional approach. So we're seeing sort of a change in the law. So for example, if a drone strikes, let's say, an alleged drug boat, right, or a militant target, IHL would ask, was the target lawful? Was the attack proportional? Whereas human rights law would attack, was the deprivation of life arbitrary? Was the due process respected? In some, these legal frameworks can sort of overlap, they reinforce each other's, but sometimes they conflict as well. So next, I talk about accountability. So how do we enforce these rules, right? So there's no single global police force, so accountability is necessarily fragmented across different levels. First level is obviously domestically, at the state level. We are the first line of accountability. Domestically, states have an obligation to prosecute war crimes, to address human rights violations under domestic law, which often incorporates international law. David Sloss wrote a whole book about that. But in practice, enforcement is really limited, not by the law, but by politics, by immunity, by lack of political will or judicial will. In addition to the domestic accountability mechanisms, internationally we have different types of courts. So for example, have you heard of the International Criminal Court, the ICC? So that's one that prosecutes individuals for specific types of international crimes, including war crimes, including crimes against humanity, including genocide, right? And the ICC has been actively investigating some of the war crimes that we hope to discuss today, including genocide in the Ukraine. There's an investigation open since March of 2022 that covers crimes committed by Russia in Ukraine, and this includes targeting civilians, child deportation, and infrastructure destruction. And the ICC has actually issued arrest warrants, for senior Russian officials, including Vladimir Putin. But the U.S. is not a party to the ICC and has not consented, so that's not really an option for us. In addition to the ICC, we have regional human rights mechanisms. I mentioned the European Court of Human Rights. There's also the Inter-American Court of Human Rights, where I used to work a few years ago. And these bodies sort of hear complaints, where states have violated human rights law. Again, states. ICC, it goes against individuals. Human rights courts address the obligations of states themselves, not individuals, right? So, for example, the Inter-American system has addressed the use of force and the detention of individuals in the high seas, which is a topic that we hope to discuss. And this is relevant, for U.S. drug interdictions, because under human rights law, the use of force must be strictly necessary and proportional. That's the standard, right? And in law enforcement, not in armed conflict, right, lethal force must be the last resort, right? But this is stricter when we talk about IHL, if we're talking about an armed conflict, right? And my opinion, because counter-narcotics is usually treated as law enforcement, not a war. Human rights law norms on the use of force are the ones that actually apply. Also, under human rights law, detained individuals, even if they're offshore, right, in a boat, even without a flag, they must be promptly brought before a judge. That's due process, because we're not at war against narco trafficking. At the UN, you also have maybe some other mechanisms. So have you heard of fact-finding missions? So there's a fact-finding mission, in Gaza. There's one in Ukraine. There's also ad hoc tribunals. So tribunals that have been created for specific circumstances. The UN is not doing that too much because it's too costly, and we have the ICC. And we have the possibility of issuing sanctions. But I'm going to talk about, a problem that we have there. Is that enforcement in international law is selective. It's uneven. Powerful states often avoid meaningful accountability. And that takes me to my final point, which is the United Nations Security Council veto, especially the role of the United States. So the United Nations Charter is the treaty that creates the United Nations. After Second World War, we created this new institution to no longer have war and protect peace and security. And the Security Council is a body that allows only a small number of states to participate, and that body is the one that has the primary responsibility for maintaining peace and security of the world. But there's what we call 5 permanent members. That's no coincidence. It's the 5 countries that won the war, right? So we have US, UK, France, Russia, and China, and they have something called veto power. Right? So that means, that by issuing a veto, they can block any resolution, even involving major armed conflicts like the ones that we were discussing. So the U.S. vetoes Israel-related resolutions, Russia vetoes resolutions on Ukraine, and China and Russia veto resolutions on Syria. So this creates a structural paralysis, right? The bottom line is that the veto turns the system into one where law is filtered through geopolitics, right? And major powers can actually shield themselves and its allies from a structural perspective. So that's why many argue that the UN, struggles to fulfill its mandate actually to maintain peace and security. Not because the law is weak, but because enforcement is actually political. So when we look at current conflicts from Gaza to Ukraine to the U.S., we're not seeing a lack of law. We're seeing overlapping legal frameworks, fragmented accountability, and a global system where power is what often determines whether law is going to be enforced. Thank you.
Professor Schwartz.
Great. So I want to dive a little more deeply into maybe kind of a specialized topic about where international human rights law and international humanitarian law can overlap in situations of armed conflict. Specifically, I want to look at the human rights consequences of attacks on civilian infrastructure in some of the conflicts that we're seeing around the world right now, and how that's affecting particularly vulnerable groups, but really all civilians. But I want to look especially at people like children, right, who are particularly likely to be harmed by those kinds of attacks. And how those types of attacks affect their right to life, but also other associated rights, right? Like the right to health, the right to food, the right to water. And those are something that we kind of call economic, social, cultural, and environmental rights. And those aren't rights that are typically really thought about in the context of armed conflict. Usually we're more worried about some of the rights that Professor Rivera mentioned, right? The right to life, the right to due process, the right to access to justice and accountability, right? But if you kind of take a step back and think about what must it be like to be trying to live your life in the midst of an armed conflict, right? Ordinary life doesn't stop, right? You need to eat. You need to have access to safe drinking water. You get sick, you need to go to the hospital, right? Your children need to go to school. What are you going to do when those systems are breaking down in the midst of your daily life, right? And what does the rule of law tell us about how we deal with those breakdowns, right? So that's really what I wanted to dive in with you right now. Because human rights law and international humanitarian law can actually tell us quite a bit about how we deal with that problem, but I think there's still a gap. There's still more work to be done. So I'm also kind of putting out a call to action to all of you to kind of come along with us and do some thinking about what more could or should the law be doing in these areas. But things are starting to change, and that is good. So I want to recall what Professor Rivera just said a few moments ago about how both international humanitarian law and human rights law are grounded in the protection of human dignity, right? And one of the ways that manifests in international humanitarian law is the prohibition on the deliberate targeting of civilians, right? The law accepts that civilians may be killed in the course of legitimate military activities, but there's no direct targeting that is allowed. And it has to be part of a proportionate attack on a military target, right? You heard about this principle of distinction, principle of proportionality. All of that's really important when we're talking about civilians. There's also a prohibition on direct attacks on civilian infrastructure, again, if it's not military necessity. And we also have a pretty universal prohibition on the use of starvation as a method of war, as well as a requirement that objects indispensable to human survival be protected, right? And especially on those two pieces, they're often kind of used together. Those are recognized really under international humanitarian law, as well as the failure to do those things can be a war crime under international criminal law that can be prosecuted before the ICC, as Professor Rivera mentioned. And it also would be something that is prohibited by international human rights law under a few different provisions, right? Right to life, right to health, right to food, etc. So one thing that's really interesting is this development that Professor Rivera was also just talking about, this recent decision from the European Court of Human Rights, where they kind of set aside this more traditional lex specialis approach to how international humanitarian law and international human rights law work together in situations of armed conflict. And it looked at situations where Russia is holding Ukrainian cities under siege and thereby depriving the civilian population within those cities of access to basic necessities like food and water. And it said, under international human rights law, right, there's an obligation, and this remains in force even during times of war, to prevent cruel, inhuman, and degrading treatment. And basically read that provision of international human rights law in conjunction with those international humanitarian law principles that I just mentioned, right? The prohibition on the use of starvation as a method of warfare, the protection of objects that are indispensable to human survival, and said, if you take those two things together, Russia, as the party that is carrying out this siege, has both a negative obligation to prevent people from losing access to these things that they need in order to survive, but they also have a positive obligation to do something to ensure that the people in these cities have access to food, have access to water, which is, again, is a really positive step, I think, in this area, because this is an area where there hasn't been enough thinking legally about what the states, the governments that are fighting against each other, or maybe non-state actors as well, what do they owe to the civilian population whose basic needs are being deprived as a result of armed conflict. I will pause there, but I will just say the thing that I did want to get to was that I do think that in the proportionality and military necessity analysis that the proponents of an armed conflict are supposed to carry out under international humanitarian law, they probably need to be incorporating a consideration of the collateral civilian consequences of any action in that proportionality analysis, and not just what civilians are going to get hit by, this bomb when it explodes, but also thinking a little further out in time. If we are, for example, bombing a target right next to a desalination plant that the population depends upon for access to drinking water, how many additional people are going to die as a result of that lack of access to safe drinking water or waterborne illness that will be propagated when that happens because of that loss of infrastructure? And that might change the answer when we decide whether or not a strike is in fact proportional in accordance with international humanitarian law. Thank you.
All right, thank you. So we do have a microphone here somewhere. Hallie's there with the microphone. Thank you. So you raise your hand, we'll pass you the mic. You can either direct your question to a particular member of the panel or leave it more general, up to you. But please go ahead.
Thanks. Very, very interesting discussion, but it seems like neither the international community nor individual countries are paying any attention to the various types of international humanitarian law, human rights law, and in the United States, our Congress and our judicial branch essentially is letting the executive branch do whatever they want. And I'm very concerned about this. There seems to be no enforcement power. So what's the whole purpose of this international law if there's no enforcement?
You want to start? Okay. So, what I would say is that basically for the last several decades, the way this has worked in the United States is that you have lawyers advising policymakers, and policymakers actually, for most of the time, cared about whether what the policies they wanted to do were legal or illegal, right? And this happens both sort of in Washington, where high-level policy decisions are made, but also in the field, in the midst of armed conflict. A military commander in the field has a JAG officer there with him, a military lawyer, who will advise on particular strikes, like we want to hit this target with this weapon, is this lawful? Right? And the military commanders in the field placed a lot of weight on what those military lawyers said. I would say high-level political leadership in Washington maybe placed less weight on what the advice they were getting in D.C., but at least they were seeking out and getting like military advice, right? And part of what we've seen, or legal advice. Part of what we're seeing with the Trump administration, which is really a departure from anything we've seen before, is that President Trump has basically staffed the White House with people who will simply sort of give him the green light for whatever he wants to do. I don't think there are lawyers in the White House who are prepared to stand up and say this is illegal. And Secretary Hegseth in the Department of Defense has specifically fired people who are trying to do that, right? And he has basically said, look, we're interested in lethality, not legality. And that's what matters, is lethality, not legality, right? So this is really a departure from historical practice that has existed for decades on both sides of the aisle. Republican and Democratic administrations have at least sort of considered whether what we're doing is lawful, and sometimes sort of asked lawyers to come up with post hoc legal justifications for stuff, which were not always persuasive, but at least they sort of made a good faith effort, I would say, to try and come up with legal justifications. And now we've got an administration that just doesn't care about that at all. And so I'm with you, I'm very concerned about that. I hope that this will be a sort of a temporary aberration and we will come back to what I would say were sort of historical norms. But whether that will happen, I don't know.
What concerns me the most is the collateral damage. Civilians are being killed.
Yes,
Two of the panelists have said that's not permitted.
right,
And
right.
not only in Iran, but in the Gulf states,
Yep,
where Iran is firing missiles and buildings have been destroyed, civilians have been killed.
yeah, I don't think Iran is complying with international humanitarian law
Of course
either,
not.
right? When I was growing up, we thought we were the good guys and they were the bad guys, right? I'm not sure we're the good guys anymore.
One thing I just want to point out is the fact that we have the law gives us a language to talk about what is right and wrong. So the fact that we can say targeting civilians is wrong, it's against the law, is a triumph of having a legal framework. Right? We're not in a world where powers kind of just do whatever they want without at least trying. We are in a state right now where many leaders around the world feel emboldened to do things that go against this long tradition. But I think it's important, especially when we talk about accountability, to take a long view. That it's very hard sometimes in the moment. Bombs drop. It feels like the rule of law has no power in the moment. But these things take a long time, sometimes generations. And if we look back at prosecutions of past leaders or others who have committed violations of the laws of war, sometimes it takes a while, but we don't forget. There's no statute of limitations on war crimes or crimes against humanity or genocide. So as long as we don't give up hope that accountability can come sometime in the future, right, then the rule of law still has power.
I'll just add really briefly, maybe as a complement to that the legal director of the International Committee of the Red Cross, which is often sort of regarded as like the body that really holds the expertise about international humanitarian law globally, was talking about this pretty recently, actually, how frustrating it is and how much strain international humanitarian law is under, going precisely to your point, but also emphasizing, and sometimes this is really hard to quantify, the degree to which international humanitarian law is not only kind of globally adhered to in the sense that like everyone has ratified the treaties, right? But that there is actually a lot of integration of international humanitarian law into national militaries, right? It's in the military manuals. It's part of the training that folks in the military receive. You have this legal advising happening in the field that Professor Sloss pointed out, and that there are a lot of lives saved by that stitching of international humanitarian law into the fabric of how war is waged, even though there are obviously these incredibly egregious examples of how that law is also being violated in the field. And so I think sometimes it's hard to kind of prove the negative, but I do think that in addition to kind of setting the norm so that we can talk about what is right and what is wrong, I think there's actually a very practical level where the law, because of the degree that it's been implemented into military training and that hierarchy, that it actually has a lot of practical effect on the ground as well.
So really quickly, I agree with you. I'm just going to take it a step further, right? We're talking about the rule of law. It's made up of different things, right? You have to have the law, so create the law, think of Congress, then you have to sort of, implement it, think of the executive, and then you have the judiciary to make sure that, people are held accountable, right? We have the law, international law, but I think it's a mistake to think of international law as this thing out there that's either of a higher standard or different than domestic law. It's the same thing. So nothing that's prohibited under international law is actually allowed under domestic law. All the military law, the state torture, for example, there's no law either at the federal, state, municipal, any type of level that actually allows torture, right? So the law is there. It's not a problem of not having law, right? We do have, as I mentioned, some powerful, just like in criminal law or civil law, powerful individuals who can get away with murder. You can have powerful countries that can also get away with violations of international law. It's the accountability mechanisms that are failing us. But I would say, because I agree with you, it's not just the international mechanisms. Those were designed in a way that they're going to fail because of veto power and things like that. But as I mentioned, the primary responsibility to hold Donald Trump and anybody else accountable is domestically. So when we talk about the failure of accountability, we must start with the failure of our own checks and balances. So.
Let me just add one more thing and then we'll go on to the next question. So in thinking about international law, I always like to draw an analogy to speed limits, right? We don't decide whether speed limits are effective by asking how many people drive over the speed limit. If that was the metric, we'd say speed limits don't work at all, right? We ask, do fewer people end up dying in automobile accidents because we have those speed limits? And I think the answer is yes. And it's the same idea here with international law. Fewer people end up dying. At least this was true, and there's a lot of data to back this up, right? At least until recently it was true. Fewer people end up dying as a result of armed conflict because we have international law, even though you can point to a lot of examples of people violating those rules, right? So it's important not just to focus on the violations, but to focus on the big picture here of, are these rules actually reducing the amount of death in armed conflict? And I think historically the answer has been yes.
Professor Schloss, you mentioned that since the institution of some of these international laws, there was a gross decrease in the number of armed conflicts. Right. Up until 2001, 2003, and now today we've got the U.S. attacking Iran, we've got the genocide going on in Gaza. Do you see or do you foresee a situation in which more countries are going to start to break international law because they see that Russia, Israel, the U.S. can get away with it? It's for anybody.
Again, that's enforcement.
Right. I think that's the fear, right? For a long time, the system worked because the U.S. was willing to stand up for these norms and take a leadership role. And again, our implementation was imperfect, We were accused a lot of hypocrisy because we're trying to get other states to comply with the rules, but we're out there violating the rules, right? But I think the U.S. for decades really sort of stood up for these rules. And as the most powerful country in the world, that made a difference, right? So, to me, the future depends a lot on, can we get the U.S. back to a place where we really think these rules are important and we're willing to comply with the rules, and then we're in a better position to go to other countries and say, you must comply too, right? But given our recent behavior, when we go to other states and say, you must comply, that message doesn't carry much weight, right? It's like, why are you like tagging us, right? Look at what you're doing. To some extent, at least, the future depends on whether we can get our own house in order. Because if we can't do that, we have a hard time. Then I do think we get into a sort of a free-for-all in the international sphere where we're back to sort of might makes right.
I have to agree with that just very quickly. This is like the domino effect. And I'm from Puerto Rico, and Venezuela's like right next door. So I have a lot of Venezuelan friends who said, but isn't this a good thing? And same with Iran. Isn't this a good thing? Aren't we, getting rid of the bad guys who are committing all these human rights violations? Aren't you a human rights guy, And my answer is always, it's a good thing according to whom, right? We already have laws that determine, what's good, the rule of law. But when Donald Trump was asked, to what extent he makes his decisions according to the law, He said, according to international law, he doesn't even care about it, and his only limit is his own morality. And that's the problem, when we don't have the law to actually have the rail guards, and it's individuals, dictators, or autocrats' own morality or lack thereof that guides us, and the next person, and the next person, and the next person is going to do the exact same thing.
I just want to add on to this idea that the rule of law helps decrease the frequency of conflict. One of the reasons why we think conflict happens is because parties don't understand each other, or there's some kind of information asymmetry. One of the ways we get around that is having systems in place that make it more likely we're going to understand each other's ideas and our wants, our preferences, how to change policy. And you probably have heard of ideas like the democratic peace theory and this idea that democracy on the whole shouldn't be fighting each other. One of the mechanisms is that the more voices you have making decisions, the less likely it is that people are going to decide, like, yes, let's go out and kill each other. And so there's a concern, at least this is something I've seen, as the US has restricted the number of voices who are involved in deciding whether to go to war and how to conduct warfare, the more likely it is that the US is going to be acting out, and that makes it harder for other countries to rely on the US to be a good actor. And so kind of going back to the earlier point about how the domestic breakdown of the rule of law or the checks and balances has actually had a global impact in the functioning of how the rule of law can help constrain armed conflict generally.
And I'll just add quickly that I think this whole conversation really underscores why the rule of law is so important at every level, right? I mean, you were just talking about kind of how lack of respect for the rule of law on one level has all of these echoes globally, right? And I think that's really what we're talking about. But I think that that's also what the current rules-based international order was really born out of, right? That's how we got to the UN and the current form of the Geneva Conventions and all of this was that we kind of did have a race to the bottom, right? Things were incredibly atrocious during World War II and everyone said, okay, this needs to not happen again. And now we're kind of veering off course from that global consensus. And I think it really signals the need for a recommitment to the rule of law in this space. And maybe some repositioning of kind of global polarity around like kind of who makes those decisions or who plays that more kind of moral leadership role. And also I think it points to the need for like a groundswell of support from, the civilian kind of population level for, greater respect for the rule of law in armed conflict and beyond.
Professor Rivera, you were talking about how in the UN there's been a sort of stalemate that comes from geopolitics, and it's making their work stagnant. I was wondering what you would see as sort of a solution or a way to mitigate something like that, although I know that it's kind of just a think piece for now.
I laugh because we just had a conversation about this, and she told me, don't say that to students, but I'm going to say it anyway. The UN is the creation of the UN Charter. It was a negotiated charter. States got together after the Second World War, and they created this organization. After the League of Nations, they said, we're going to create this one, right? Again, it was created by those who won the war. That geopolitical scenario, of, 70, 80 years ago, no longer exists. In that Security Council that I mentioned, you have those 5 powers that have veto power. You have 13 others that are not permanent. They get to, rotate those seats, and everybody's trying to all states are elbowing each other to try to get there. But still, even if they get there, they don't have veto power. So my opinion is we need something else. The UN, I think, has served its purpose. And I think reform is not the solution because you would have to just do away with the UN Charter. You have to think of something similar, but without that sort of post-World War II dynamics where some countries, are so powerful, and now we have other countries who are even more powerful, and they don't have veto power here. So that's my sorry.
Let me give a slightly different perspective here, although I don't disagree with what Professor Rivera is saying. But when the UN was created in 1945, the idea was that the 5 permanent members, that is, at that point, the Soviet Union, China, France, England, and the United States, would act together to enforce the basic rules in the system and make sure, but collectively they had sufficient power to ensure that other states wouldn't violate the rules, right? That quickly fell apart with the advent of the Cold War in the late 1940s. And basically for a period of about 40 years, the UN Security Council was largely paralyzed because we were divided between sort of the Soviet bloc and the Western bloc, and they couldn't agree on much, right? We had a brief period from, I would say, like 1990 to 2001, when the UN Security Council really did function sort of like the way the framers of that document wanted it to function, right? The Soviet Union fell apart, it was replaced by Russia, Russia was relatively weak, China was relatively weak, and they were willing to go along with the US and all sorts of stuff. And this was a sort of a brief period when the Security Council actually worked pretty well. People weren't exercising vetoes. We were getting stuff through. We were getting stuff done. What really blew that apart was sort of 9/11 and then the Iraq War, right? And then things sort of turned in a different direction. But I guess it's a sort of an open question. If you want to see the system to work better, right? What is the more realistic scenario? We keep the current structure and somehow find our way back to a system like was existing in the 1990s, where the great powers are cooperating with each other, or we scrap the whole system and do something new and different, right? I'm not sure what's the more realistic. Neither one of those looks like a terribly realistic scenario right now, but those are both options for how we can get to someplace better, and which is the more likely option, I don't know.
I realized that my answer was depressing, so I'm going to add a little bit to the end, which is sort of what you were saying right now. Until that happens, or if and until that happens, I think we need to elect better politicians. We need to elect better leaders who are going to use that power in a way that doesn't promote, stagnation and all that. So it's up to us, ultimately. Is that motivating?
I wanted to first express my deep concern for the impact that's already occurred to the civilian infrastructure of the people of Iran, as well as the threatened damage in that the United States has threatened that if they do not open the Strait of Hormuz, that they're going to hit the nuclear sites. My fear is not only for the survival of the people, but also for if and when this conflict is to end, not only are they left in a vulnerable state, but it also, I fear that it will leave them in a state that's vulnerable against their own government, and that might put them in a place where they're more susceptible to the human rights violations and the effect of the IRGC, and halt their organic efforts for regime change. My question is, if we just leave with our hands clean, is there any duty to mitigate the damage that's already been done to support the people and potentially allow them to seek out the secular democracy that they're so hoping for?
Britton, why don't you start?
Okay, I'll try and make it start. It's a big question. I think there are a lot of moving pieces.
That's why this is very loaded.
No.
It's personally affecting me and my family at the moment, which is why I asked.
No, and I'm so glad
Sorry
you
about that.
did ask, and I'm sorry for that. It's a terrible situation. And I think the way the war is being conducted is particularly concerning. I mean, it's unfortunately not, as we've been pointing out, unusual in this moment in time, but it is not the way it should be going. But I do think this kind of goes to the point that Professor Dalton was making earlier about the kind of longer timeline of post-conflict recovery and reconciliation, peace building, transitional justice, right, as well as accountability under international criminal law at both sort of the international and domestic level for perpetrators of violations. And I think especially, there's sort of two at least really big pieces there, which are kind of reconstruction of civilian infrastructure that are essential for life. Like, who's going to pay for that? How's that going to happen, right? And so I think that is a place where an institution like the UN can play a really important role in terms of establishing a fund for reconstruction. And I'd hate to see something like what the U.S. is proposing in Gaza to happen there, right, where it essentially becomes like an investment property for the Trump business, right? Like we don't want that to happen. But I think on the political level, when you talk about people's demand for regime change and the very real threat posed by the Revolutionary Guard, I think that's a place where, on one end, right, like I think that is a piece that the U.S. really seems to have failed to think through on the front end before entering into this conflict. And I have continued to kind of see a lack of thinking about how that piece is going to be handled. But I think there have been some good examples in other conflicts of the establishment of kind of truth and reconciliation commissions or other kind of post-conflict transitional justice mechanisms that are intended to place, stakeholders on various sides at a table together where they can negotiate in the way that Professor Dalton was actually just talking about, right? But what is the future supposed to look like here? But I think there's a very real risk that there's going to be a power vacuum created as a result of this conflict, and the U.S. is going to exit before that issue gets resolved. And Israel's just trying to kind of bomb as much as they can before that happens, right? But that there will be actually like a radicalization of the government that will result in further repression against the Iranian people. And so I think that like any negotiated end to the war needs to account for all of those dimensions and put in place mechanisms and financial commitments in order to give effect to those mechanisms, so that those things can be navigated in a way that is to the benefit of the Iranian people. I don't know if others would like to jump in.
Go ahead. All right, I'll jump in.
I gotta stop it here.
So I've been both reading a lot of stuff written by Iran experts and listening to stuff from Iran experts. And one of the more, I thought, insightful pieces I read said, in thinking about the Iranian people, you gotta have this sort of 20-20-60 view, right? 20% of the population, at least according to this author, support the regime. 20% are vehemently opposed to the regime. And 60% really just want a better life, right? And if you can give them a better life, they're going to be okay, right? And so I think the call for we want the Iranian people to rise up and overthrow the government is wildly unrealistic. Because if this author is even remotely close in saying 24, 20 against, the 24 have all the weapons and the 20 against don't, right? So that's not a situation that lends itself to sort of revolutionary regime change, right? So assuming we can bring an end to the conflict, I would hope what the United States and other countries would do would be come up with a post-conflict resolution where the regime actually tries to give a better life to that 60% who want a better life, And I think there are lots of things we can do to sort of nudge them in that direction. But exactly the wrong thing to do is say, we're going to blow up everything, right? Because that pushes it in exactly the opposite direction. So, I don't know quite how we get there, but I think that's what we should be trying to do. I don't have a lot of faith in this administration to go that way, but it may be that if the conflict comes to an end, we get, Europeans and others stepping in who will try to exert their influence to push things more in that direction.
I just want to give a quick two points. The first point is I think stories like this have to be made public and told to policymakers. They need to understand this. That's the first thing. The second is to think of historical examples. World War II is the obvious one because that's kind of the big event. But if we go back and remember and go look at Berlin today versus Berlin in 1945, part of the U.S.'s approach to the post-war era was to rebuild Japan and Germany. So we can think of things like the Marshall Plan or other efforts like that in how the U.S. could approach, right? We can have the imagination to think about a U.S. supporting rebuilding different areas around the world, including in Iran. And Ukraine is a great place where this is actually happening right now. People are thinking about what does Ukraine look like if this conflict gets resolved? How do we resolve the thousands and thousands and millions of claims that people have against Russian officials, the Russian government, for destroying their homes, their businesses, taking away all these different parts of your life, even though they survived, right? They might have survived without anything, right? No possessions, right? They missed education and all the other effects of the war. So there are other places we can look at as instructive for what we could do here.
Just going to say that studies have shown, that where people's needs are met, and there's no discrimination or either racism or religious wars, there's no war. If you think of the big picture here, the U.S., as was mentioned before, the strategy is to submit or create change, regime change, through force. But if you add to that the fact that we're no longer funding things like U.S. aid, then how are we expecting in the future to not have people in different countries, have or rise up because their needs are not being met? So this is a ticking time bomb, for the future. Right now we're bombing Iran, but the lack of international support that we're seeing is going to have, I think, repercussions ultimately.
Maybe one more question?
So because international law is mainly governed by these big powers that are also simultaneously committing and creating these war crimes, how does international law ensure that those same crimes are not getting overlooked? For example, like Israel towards Palestine and specifically Gaza, especially when a lot of nations, especially bigger actors like the US and Israel itself, does not recognize Palestine as a state and thus almost is an invisible voice to their own land in their country.
I'm going to add one really practical answer to that question. I think there's a much bigger political answer to that question that maybe we can all contribute pieces of. But I think human rights fact-finding is actually an incredibly important tool in this context where international law is being violated somewhat with impunity by very powerful states. And I know that, for example, in that case from the European Court of Human Rights that Professor Rivera and I referenced earlier, where Ukraine and the Netherlands were suing Russia for both violations of international humanitarian law and international human rights law during the Ukraine-Russia conflict, the quality of the documentation of the violations was a major factor that enabled the court to hold Russia accountable. Now, whether the court's ruling will have any practical effect on Russia in the near term, probably not, right? But you've both vindicated the claims of the victims by having an international court or regional court in this case look at the facts and say, yes, your rights were violated, Russia is responsible. There's value in that, first of all. But second of all, you've also preserved this record that in great detail, right? The factual annexes to that case are like a combined, 1,500 pages or something, right? Probably more. You've really captured what happened and who did what, right? And that leaves the door open for accountability when the political situation allows for that to occur. And it provides, I think, a greater basis of legitimacy for people to make that call for accountability, right? Say, we have the evidence. We know that this happened, right? No one's going to tell us, no one's going to gaslight us and tell us that you didn't do what we think you did, right? We have documented it. And so that's why I think, for example, the work of the UN's Commission of Inquiry on Gaza has been so important, for example. But in many of these conflicts, people are at great risk, right, on the ground, documenting in as close to real time as they can what is happening. And I think that's a real contribution that is being made to that problem that your question signals. Doesn't present an immediate solution, right, but it is a really important component. Do others want to tackle some of the thornier political questions that Farah has raised?
I'll say one thing briefly, which is one of the dynamics that's been going on for too long in the Israeli-Palestinian conflict is that Netanyahu strengthens Hamas and Hamas strengthens Netanyahu. They feed each other. And there are lots of people on both sides who would really like genuine peace. I did host an event here in the fall for the university where we had a dialogue between Israelis and Palestinians who genuinely want peace, right? And the tricky thing, and I don't know how to do this, right? I don't have a good idea how to do this, but their voices need to be strengthened. And Netanyahu's got to go, and Hamas has got to be weakened, right? And if Netanyahu goes and Hamas is weakened, and we can actually lift up the voices of what I believe are really the majority of people in both Palestine and Israel who really would like peace, I think they will find ways to work together to make things better. But at the moment, their voices are drowned out because we have this sort of really negative cycle of, Hamas feeds Netanyahu and Netanyahu feeds Hamas, and that just makes everything worse for everybody. All right, I think we're out of time, so thank you all very much for your good audience.